Any other requests for continuances?
Your Honor, I have a request of dismissal about the court today, this morning at 9.
Okay, yeah, we'll definitely take that up. At this point, I'm just looking for matters that we can quickly rearrange schedules on, and not necessarily a substantive motion asking for a dismissal. So we'll call that your case in matter of course.
All right.
That being said, looks like Ms. Russell's coming forward, taking a seat. Good morning. And I'll ask if Mr. Matthew Russell is on the line. Matthew Russell. All right, Mr. Russell, if you are on the line, I'm not able to hear you, so make sure you're unmuted and please state your name. While we're waiting for him, Ms. Looney is here. She represents the state. Ms. Looney, can you hear me okay?
I can. Good morning, Your Honor.
Okay, good morning. All right, let me just pull up my minutes. So we're here on the, looks like basically a finalization of the divorce. It looks like there was a joinder filed by Mr. Russell joining in with Ms. Russell's requests. And that was signed back on June 5th. And the 90 days have clearly passed since that time. And the petition asked for several different things, the parenting plan, name change to Bonnet, is that correct? Okay. And parenting plan, and then the state is involved and they're asking for child support and uninsured medical expenses to be allocated and provision of health insurance and the like. So number one, we'll kind of be preemptive and Ms. Bonnet. Ms. Bonnet, did you receive the state's motion or their paperwork related to the child support?
I have.
Okay. Do you have a position on what they're asking for?
I'm not, I mean, they want to ask him for it, but he's on SSI, so we know that it won't go through. So, I mean, I don't care either way.
Okay, no strong feelings one way or the other. Okay, and Ms. Looney, anything to add to your the state's request related to child support?
No, Your Honor. We've assessed both parents at zero income due to SSI, and we have a statutory minimum $50 request from the child support.
Okay, and so basically you're asking that Mr. Russell be ordered to pay $50 per month, and then the uninsured medical expenses be divided between the parties and the parents, if they can, provide health insurance coverage for the child.
That's correct, Your Honor.
Okay. So Ms. Bonnet, so related to the finalization of the divorce, I'm just checking with you to see if you have filed any proposed orders related to the divorce and decree and what they call findings of fact.
I turned all my paperwork in.
So you did turn it in?
Yeah.
Okay. How long ago did you turn it in?
I've been in the 15th of December. I met with the court facilitator.
Okay. All right. And then, Madam Clerk, any on your end, do you have those documents? Is there a record of those?
You should have been provided because she did meet with me.
Yeah, I saw the certificate. Yeah. Okay, that'd be great. And do you think we'd get a response from Ms. Cayley this morning?
Yes.
Okay. So Ms. Bonnet, what I'd like to do is just pause on your case for a little bit. Our in-court clerk is going to check with an out-of-court clerk to see if she has those documents. If she does, she'll bring them in and then we can sign off on the paperwork. Yeah, and then let me touch base with Ms. Looney as far as your proposed orders. Did you file those with the court? Do we have those proposed orders, or is that something you could prepare?
The originals were sent over on December 18th, Your Honor.
Okay. Well, and the clerk was indicating yes that she did see those. So I think when we hear back from the out-of-court clerk, we'll know a little bit more. So that's a long way of saying that I think we're almost there, but we just need to figure out where those documents are, and then we'll return to the case in just a little bit. So I'll just put this in my holding bin, and we'll come back to it. Thank you for your patience. We can get started. All right. So first off is Christopher Olson, either present in the courtroom. Yep. Yes, all right. Good morning, Mr. Olson. Come on up and take a seat, whichever side you want to be on. No preference on my end. And then Tiffany Johnson, are you on the line this morning?
I'm here.
Okay. And I see that your name on the Zoom is Steinweg.
Yes,
okay.
That's I'm married since we began this case.
Okay. All right. So I'll refer to you as Ms. Steinweg and then Mr. Olson. Okay. So we're here today for a pre-trial hearing in preparation for a trial that is set for the 29th of January of this year, so the end of this month. And so generally with a pre-trial, we try to make sure that all parties have all the documentation from the other side, that the other side says, hey, at this trial, I'm going to bring in these documents, and I want the court to look at these documents. And generally beforehand, we share those documents with each other so everybody has an idea of what's going to be presented. It's also an opportunity at this pre-trial to make sure we know how many witnesses are going to be called, who those witnesses are, their identities. And so we try to share that information here also. And just in general, just try to make sure that everybody's prepared for the trial. And we could talk about procedure. If you have questions about, how does a trial roll? What are the steps involved? We can certainly talk about that here today. But that's the general purpose of our pre-trial hearing today, is to get ready, make sure everybody has all the information that they need to have in preparation for the trial, and kind of answer some of your questions as far as expectations or the procedure that will be followed at the trial. So maybe we could just start with both of you and just asking, maybe I could just ask Ms. Steinweg, as far as witnesses, what witnesses do you plan to call during the trial?
When I turned in the paperwork, I didn't put any witnesses
Okay.
down.
So am I correct in assuming that you plan to testify and present evidence?
Yes.
Okay. And then any other persons that you think you may potentially be calling?
No.
Okay. And then a similar question to you, Mr. Olson, as far as the trial, what witnesses do you anticipate calling?
I don't have any witnesses, Your Honor.
Okay, so and I assume that you would be presenting and testifying?
Yes.
Okay, all right. And let me ask the parties, as far as what are the issues, the main issues that you're concerned about, that you want the court to hear about and rule on, Mr. Olson?
I guess that when we got the results from the hair follicle, it went back to where I got clean in July and put myself into treatment, and like I was kind of confused how the other judge reacted, like that it was like I was dirty then, but I wasn't. And since that time I had gotten myself into outpatient treatment, and I also got myself into a mental health counselor, and was getting all back on the right track.
Mm-hmm.
And I just kind of took the wind out of my sails. I hope the court looks at that and takes that into consideration. And I know that I didn't get my paperwork, I guess, turned in on time, and I was missing 1 0. So the other judge couldn't take my paperwork, but we've fixed that, and hopefully it's I did. Now I texted Miss Steinweg the copies that I have that I turned into the courts. I hope that that's okay.
So what are those copies?
There's 2 pieces of paper from my treatment facility, and there's 1 from my mental health facility.
Okay. All right. Okay.
If
So it sounds like that the things that are important to you, you're talking about some substance use disorder or drug and alcohol evaluations and hair
Yes.
follicle tests, and
Yeah.
also some mental health evaluations and treatments, and I think all those would be relevant for the issue of parenting plan. Is parenting plan at issue?
Yes.
Okay. And is child support, does that need to be decided also?
I don't think so. I'm behind on that. I lost
Okay.
my job in last December, like over a year ago, and I've been waiting for disability. I got diabetes, and it really messed me up, and I'm unable to work at this time. So I've been waiting to get the disability going on. It's kind of been a nightmare.
Okay. All right. Thank you. I appreciate that input. Ms. Steinweg, as far as the issues that you feel that you'll be presenting and talking about at the trial and you want the court to rule on, what are those?
It's definitely the drug use and the amount of time that he is spending with his son. We have a temporary parenting plan in place currently, and he is supervised by his mom, or Chris is supervised by his mother. And my son says that he's only even showing up for 2 hours a day to see him. So I'm just,
That's not true.
it's the drug use,
No, we're not going to decide any
parenting,
issues today.
the
Go ahead, Ms.
parenting
Steinweg.
plan change. As far as the child support, he's over a year behind, but I have contacted the Division of Child Support, and that's through their office now. And also there's some medical bills that have been, my son got a concussion while he was at his dad's, and in our parenting plan, it states that he will pay a portion of medical bills. And I don't know how to go about that either. So.
Okay. All right. So it sounds like both parties are apprised of kind of the main issues. There's a parenting plan is that issue, child support is that issue, and issues that impact those particular areas. So generally, if you have documentary evidence that you want the court to consider, you can do that in one of two ways. One, you could take a look at, you can Google this, you can look up ER 904, Evidence Rule 904. That's a rule that you can utilize to present evidence, and you can submit it to the court. If you submit it in a timely fashion and the other side doesn't oppose it, then that evidence is admitted into evidence. So that means the court will consider it. The other way to get evidence, documentary evidence into the court, is to bring it on the day of trial and bring copies for the other side and for the court. So if you have documents that you want the court to look at, bring 2 copies. And then we can talk about that. So that's kind of the general contours of the issues that we'll be addressing. So it's a good idea to maybe write those things out, or at least have the highlights of the particular items that you want to cover, because sometimes when you get at the day of trial, it's pretty stressful and you forget things. So if you make sure you write down, you kind of have an outline of the things that you want to cover and talk about, and be prepared to present that. Generally during the trial, we start with an opening statement. Opening statement is just say, hey, this is what I think this case is about, and this is what the evidence is going to show. The petitioner will go first. So Mr. Olson, you would be the first person to go with your opening statement if you want to give one. And then if Ms. Steinweg wants to give an opening statement, she can give hers. And then after that, then we would turn the time to Mr. Olson to call your first witness, which it sounds like it would be you. And you would call yourself as a witness, and then you could share the information that you want to share. After you've shared that information, Ms. Steinweg is permitted to ask you questions about information that you've presented. And then you can also give additional information after she's questioned you. And then we give her another opportunity to ask you questions. So that would be your testimony. And then if any other witnesses that you want to call, you could make sure that they're here on the day of the morning of the trial. And then you could go ahead and ask them questions that you feel supports your position. And Ms. Steinweg would also have opportunities to ask them questions. In like manner, once you've finished presenting your testimony and your case, then we turn the time to Ms. Steinweg for the calling of her witnesses, which I assume would be her, and then any other witnesses that she would like, and you'd be permitted to ask her questions and any of her witnesses' questions. And then when it's your turn to present evidence, when you're testifying, if there's documents that you want to present, and you haven't done that ER 904 process, then you could just say, Judge, I want you to consider this. I want to admit this into evidence. I want you to look at it and think about it and be part of your decision. So you can present that during the trial. And again, if you need to have copies for the other side so they can see what that document is. After you've each called all your witnesses and testified and presented whatever documents or other evidence you want to present, then we go to closing argument. Closing argument is just a fancy way for you to argue your case. Basically, this is what I heard during the trial, and this is what I want, and based on the evidence presented, this is why I should get it, and that's why and this is why you should rule in my favor. And after you've given your statements or your closing arguments, then the court will either do one of two things. One, it'll give you a ruling right then and there. They may take a brief recess and come back and give the ruling, or they may take it under advisement, which means that they would either write out a decision or have you come back at a later date and they'll give you an oral decision. And after that's completed, after the decision is made, then there would be orders that would be prepared, basically orders that summarize what the court ordered. So if the court would verbalize X, Y, and Z, this is the parenting plan, this is child support, then that would be documented and everybody get a chance to look at that proposed order, make sure it's correct and accurate, and then that order would be signed and filed, and that would conclude the case. So that's kind of procedurally an overview of the case. Ms. Steinweg, Mr. Olson, do you have any questions about that, the general procedure of the trial?
No.
Okay.
Am I able to call my husband as a witness?
You're welcome to call any
Okay.
person as a witness that you'd like.
Okay.
Your Honor, what was that called? The ER 904?
904, evidence rule 904.
Okay.
Yeah.
And then a question about like, so she's saying that, Zach's saying that I'm only coming over for 2 hours. I would not like to bring my mom into the courtroom. Could I have her like maybe write something out saying, I guess, how many hours I've spent a day?
Yeah, as a general rule, the court prefers live testimony, and because we can see mannerisms, we can see the manner of presenting the testimony, and generally, if somebody writes a statement, it's hearsay. It's an out-of-court statement offered to prove the truth of the matter asserted. That's kind of the legal definition of hearsay.
Okay.
So generally, if you want somebody to testify or share information with the court, they have to do it in person.
Okay.
It's a good question. Ms. Steinweg, do you have any questions?
No. As far as the readiness hearing, what happens there?
The readiness hearing, which will start on January 24th at 11:30, basically that's the final call. Like, is everybody ready? Great.
Okay.
And then it'll just be a confirmation everybody's ready, that we'll be here on the 29th of January at 8:45 to do the trial. So the readiness hearing will be the next step to make sure that everybody's ready to go, so we don't lose a court day.
Okay.
Mr. Olson, any other questions?
I don't think so.
Okay, Ms. Steinweg, any final questions?
No.
Okay, thank you both for being here. We will
Thank you.
we'll next reunite on the 24th of January at 11:30. I'll ask those, thanks to those parties who are present. Ms. Ashley Basera, are you here?
Yes, sir.
Okay, welcome to you. And Joseph Basera, are you here today?
Yes, Your Honor.
Okay, great. Welcome to both of you. We're here today for a presentation from an order or a hearing that was held on December 27th. And so on the 27th, both parties were present and there were findings made by the court. And I'm just curious, did the parties submit proposed orders for the court to review and sign off on?
Yes, sir. I did it that Friday. I drove up, took the day off of
And
work.
we'll check with Madam Clerk. Oh, yeah. Yeah, let's do that. So
Joe and Keith were both served with copies of the paper, and I got confirmation that they both received them.
okay, great. So Madam Clerk, she just stepped off out of the courtroom for a little bit. She's going to go check in the back area of the courthouse. It's unusual that we don't have all the proposed orders here. As a general rule, I come in with a stack of paperwork, and I wasn't given a stack of paperwork this morning. And with your case and another case, I think it strikes us all a bit as being a bit unusual that we don't have those. So she's going to just take a moment to find those documents, see if she can find those. So we're just going to pause here in the pool, if you will, and just float for a little bit until she comes back, because we really can't do anything without her being here because she's the record keeper. So we'll just pause for a second, and I appreciate your patience.
Okay, I just have a meeting that I'm supposed to be to in like 15 minutes. I'm at work. I couldn't take another day off of work for this. So.
I assure you, we will not purposely unduly delay.
Thank you.
All right, so we're still on the Basera matter. So let me just leaf through the proposed orders here. I have a copy of a proposed parenting plan that was presented by Ms. Basera. And then, Mr. Basera, did you receive a copy of that proposed order?
Yes, I did.
Okay. And I'll note that Mr. Lawrence is here as the guardian ad litem. He's on the line. Can you hear me, Mr. Lawrence?
Yes, I can.
Okay, great. Welcome to you.
Thank you.
So with regard to the parenting plan, Mr. Basera, do you have any objections to that order? Meaning, from the hearing that was recently held, did Ms. Basera accurately capture what the court had ordered at that hearing?
I did have questions though.
Okay. Do you have any specific questions on that proposed order?
So there's two of them. Am I to pay for the evaluation? Because I wasn't clear on that one.
So I did a quick review of the hearing minutes from the last hearing. I see that the court adopted the guardian ad litem recommendations 1, 2, 3, and 6. The psychosexual evaluation needed to be completed, and that's the one you're talking about, right?
Yes.
Does either party, Mr. Basera, Ms. Basera, Mr. Lawrence, do you recall if the court specified who would be responsible for that?
I think the court had said he was going to be responsible for that. Because they also said that they weren't going to require him to provide professional supervision because they were already asking him to put out so much money for the psychosexual evaluation.
That's my recollection as well, Your Honor.
Okay, thank you. Mr. Basera?
Yeah, I don't know. I looked into it and I can't afford one of those. It's at least $1,000.
Okay. All right. As far as it sounds like the court specified that Mr. Basera would be responsible for paying that, and Mr. Basera has indicated that that's going to be problematic. So I'm just going to add that to this here. Just one moment.
Your Honor, if I can interject for just 1 minute.
Go ahead.
Parenting plan down at the bottom, it says evaluation or treatment required, and it does indicate that he undergo a psychosexual evaluation. There was extensive discussion during the last hearing about whether or not a polygraph examination would also be required. And Commissioner Carmi was not going to specifically order that. However, she did say that in the event that the evaluator felt that he or she needed that polygraph examination, then he would be required to undergo it. And that's not reflected in this particular parenting plan.
Right. Thank you. Mr. Basera, do you have any input related to that comment?
Yeah, but I think that Mr. Lawrence is just pressing an issue that needs to stop because he's going on the side of being biased and keeps bringing that up. And the judge, she made it quite clear that, you know, if it was, so he did say that, but she wasn't going to order a standalone one, and because it can't be used as evidence. So I don't know why he keeps doing that. It's kind of ridiculous. It feels like he has something because he keeps bringing up his work history. So it's just.
So I think he was just bringing it up because I didn't add that on there on the proposed parenting plan, because I just put that if further treatment was needed, that you would follow those orders, and that would be one of those further treatments.
Okay. Well, I appreciate the input from the parties. So on page 3 of the proposed parenting plan, where it talks about the evaluation is required, and that I wrote on the line where it says that Mr. Basera get the psychosexual evaluation and start to comply with treatment as recommended by the evaluation, including a polygraph if required by the evaluator. So I just added that language. So I think that'll suffice. And that sounds like that's an accurate rendition of what the court ordered on the 27th.
Thank you, Your Honor.
Other concerns, Mr. Basera, on this proposed order?
Yeah, so can we put something in for makeup time? Because Aiden was apparently sick and I'm only getting 3 hours a week. And so she asked to miss that one last Saturday.
Okay, so let
Yeah,
me just check with the
unfortunately, all three of
parties.
my kids
So
at home got the
hold on, Ms.
plague at the same
Basera.
time.
Ms. Basera, hold on. So, Mr. Basera, on the 27th of December, did the court make a ruling on makeup time? Because that's what we're here on today, is basically limited to what the court ordered on the 27th of
Yeah,
December.
no, they didn't, because I forgot to ask anything.
Okay,
I didn't think it would happen. But I mean, if Ashley's willing to, work that out with me, I'm fine with that. But
okay. So I'm gonna pass on making a ruling on any makeup time, just because we're here for presentation, and it's solely what the court ordered back on the 27th of December. So if the parties want to agree, the parties are free to agree with whatever they'd like to agree to. However, if there's a desire on your end, Mr. Basera, for makeup time, then you could file a motion with the court and have the court make a ruling. But for today, I'll pass on making any
Okay.
decision on that. Right. Any other issues related to the proposed parenting plan, either Mr. Lawrence or Mr. Basera or Ms. Basera?
no.
None for me, Your Honor.
Okay. All right. Hearing no additional items, I have that order and I'll sign off on it, today being the 10th of January.
Your Honor, I do have a question. Are we going to put a time limit on when he needs to have that psychosexual evaluation done, or is there going to be another court date where we can, like, if he can't afford it, then he can't afford it, and that's, a big part of that.
So I'm not sure about the timeline. Was that a discussion that was had before the court on the 27th of December?
No, she just said that he needed to do it.
Okay. All right. So I'm not going to add or detract from what the court ordered on that particular date on the December 27th. So I'm not going to make any additions as far as time frames. If the parties feel that's important, you could bring a motion and have the court make a specific ruling on that. Otherwise, I've signed off on the order as presented and modified slightly by those two items that I added. One, that if the polygraph is requested by the evaluator, that Mr. Basera will need to do that. And then I also wrote that Mr. Basera is responsible to pay for the psychosexual evaluation. All right, so I've signed off on that order. Thank you, everybody, for your assistance today.
Thank you.
Thank you.
Hopefully they're here. They are here. So that's good news. All right, so we have findings and conclusions. We have a final divorce decree, a parenting plan, worksheets from Ms. Looney, and a child support order from Ms. Looney. So it looks like everything's in order. Any concerns on those orders that you submitted, Ms. Bonnet? Okay, Ms. Looney, any concerns on your end as far as child support?
No, Your Honor.
Okay, great. I've got those orders. I will take a moment to sign them right now. And if you want to wait until I've signed them, and I can tell you I've signed them, otherwise we are done.
Now I can come back when I have the cash to get copies, right?
Uh-huh. Yeah, I think, Madam Clerk, she could come as early as maybe 2 days.
Okay.
About 2 days to get those.
Okay.
Yeah. And then I'll just sign those. Any other questions, Ms. Bonnet? We should have, okay. Ms. Stephanie Lakey, are you on the line?
Yes, Your Honor, I am.
Okay, good morning. And do you prefer Lakey Jones, or what's your preference?
Just Jones.
Okay, Ms. Jones. Okay, very good. Ms. Jones is present. And then Mr. Kenton Lakey, are you on the line?
Yes, I am, Your Honor. Good morning.
Good morning. Thank you, Mr. Lakey. And Amy Turnbull, she's the guardian ad litem. I see she's on the line. Can you hear me okay, Ms. Turnbull?
Yes, I can, Your Honor. Thank you.
All right, very good. Welcome to you. All right, we are here today for an interim guardian ad litem report / review, and I'll just double check with Ms. Turnbull, see where we're at.
Well, I have been making progress. I think that generally we are on track. My one concern is that Mr. Lakey has not been able to pay the balance of his retainer. he has a balance of $1,050 left and has not been able to make progress with that. So that is right now my only concern in terms of progress with this investigation.
Okay. All right. Thank you. Mr. Lake, any input related to that to help move the matter forward?
Well, with doing my group therapy and doing reunification, things have been tight. And hopefully this payday, I'll be able to make a payment of some sort. I don't know how much yet, but I've also got bills that are behind too. And
Okay.
I've been trying to catch those up.
All right. So it looks like it's I was looking at the Guardian ad litem report from September 15th of last year. It's an indication that it's a 50-50 split for the cost of the Guardian ad litem fee. So obviously that's very important, Mr. Lakey, to make every effort to make that payment to move the case forward. So if I'm not sure if you and Ms. Turnbull have agreed to any terms, but obviously payment is people don't work for free. And any efforts you can make on that would be most appreciated to be able to move forward.
That's fine. I'm just trying to work on it.
Sure.
Hasn't been easy.
All right. So, Ms. Turnbull, you said that you're making progress. Generally, so I'm not sure where we're at. So the final report is due February 7th, it sounds like, correct?
Yes, and I'm very close to be able to complete that report. I'm hesitant to do so without payment, or if we can make an arrangement, to be paid after.
Okay.
I'm open to suggestion.
Yeah, Mr. Lakey, do you have any suggestions?
I don't have any problem, getting it paid. It's just getting it paid. I'm not gonna not pay or anything.
Okay.
That would get me even a bigger hole.
Yeah, I would encourage you to communicate with Ms. Turnbull and make a plan on how you'll satisfy that obligation. So she knows that what your specific plan is. I don't know if that's $600 every month or $300 every 2 weeks or what your plan is, but she needs to have some concrete statements and plans from you to be able to move forward. So if you could communicate with her before the end of the week and then put that in place, that would be greatly appreciated.
Okay.
So, Ms. Jones, do you have any comments at this point? We're still kind of waiting for that report to be finalized, but.
No, Your Honor, I don't.
Okay. Ms. Turnbull, any final comments?
Well, would you like me to complete the report or wait for payment? How would you like me to proceed?
I would like to see that the Mr. Lakey and you have communicated, and he's shared with you his specific plan
Okay.
to satisfy that obligation. And then if you feel that that's adequate, then you could move forward. If you feel that's inadequate, we could note it up on the docket and we can talk about next steps.
Okay. Thank you, Your Honor.
Okay. All right. So at this point, I think that concludes the hearing. So just best efforts. Yes, sir.
If I may ask, the reunification counselor had asked if Mrs. Turnbull could join in a session with Rosie and I on December 27th. She wasn't able to make it. We have another session tonight if she would be able to make that.
Okay. What time is that at?
7:15.
And what location?
I don't have the address. It's on First Avenue.
Is it Counseling Associates?
Yes, I think that's what it is.
Okay. So I'll allow the parties.
I should say Third Avenue. Sorry.
Third Avenue, right?
Yeah.
Changes names. So Ms. Jones, you can do with that information as you'd like. To allow you to make your decision. So.
Well, that was for Mrs. Turnbull.
Oh, that was for Ms. Turnbull. Sorry.
Yeah.
Ms. Turnbull, any comment on that?
Well, it's going to increase my costs at this point. So, and I'll have to look at my schedule to see if that's,
sure.
it's,
Yeah, I mean, sometimes guardian ad litems will attend things like that. Other times they'll just provide input just with the provider at a separate time, and other times they will just, or the guardian ad litem would review that information. So unless there's a specific request from the counselor, if that counselor is making that request, I think the counselor should probably make that request directly to Ms. Turnbull if that's something that's important for the counselor. But if there's not a specific request from the counselor for that purpose, and that the counselor hasn't made that, then I would assume Ms. Turnbull probably would not be present, and she could review any reports that come of that meeting tonight.
I'll reach out to Ms. Brandhorst directly.
Okay, great. Any other final comments or questions?
No, sir, Your Honor.
Okay, Ms. Jones?
No.
Ms. Turnbull?
Yeah, I'm here.
No,
Okay,
thank you, Your
welcome to
Honor.
you, sir. All right, thank you.
That'll
And then
conclude the
Tiffany
hearing.
Gizy, are you
Yes,
present? Okay, welcome to you, Ms. Gizy. All right, today we are scheduled for Mr. Gizy's motion for adequate cause to modify the parenting plan. And let me just double check one quick item. Let me just confirm with the parties, because I had my notes indicate that this is Mr. Gizy's motion. I just want to make sure that that's accurate.
Yes, it is.
Okay. All right. So as far as service, let me just touch base with the parties as far as service of Mr. Gizy's motion. I show that on December 26th, service of the documents was effectuated on Ms. Gizy by leaving those documents with her or a responsible adult. And then I just wanted to touch base with Mr. Gizy. Under our local rule 88B2, it states all domestic relations motions shall be filed and served upon all parties not later than 21 days before the time specified for the hearing. And then the responses to that shall be filed and served on all parties not later than 3 p.m. 14 days before the specified time of the hearing. So what I'm seeing with the service, that it appears that there's insufficient time or inadequate time under the rule. And that would mean one of two things. One, it could be that Ms. Gizy waives the service requirement and says, hey, I just want to go forward. I'm okay that the fact that the timeframes weren't complied with. Or if she objects to the hearing happening today, we would likely set it over so it's within the time frame specified by the rule. So any questions about that information or comments?
When I filed, they told me that I had to file them, and then I asked them when the court date would be, and they said that when I filed, everything was within compliant, but if not, we can move it over.
Okay. And Madam Clerk, your general understanding related to the service of documents for motions, the civil rule basically says 5 days, but under domestic relations cases, that's when you review kind of courthouse facilitator stuff, that's what you would review, and it's 21 days. Okay. Mr. Gizy, thank you for your comments. Ms. Gizy, do you have any input?
I was able to get my response returned to him and everything like that, so it should be good to go.
Okay. So if I'm hearing you correctly, you'd like to proceed today. Is that accurate?
Yes, that's correct.
Okay. I want to touch base with you on a second issue, specifically to Ms. Gizy. So in your responses, you filed 5 declarations from individuals supportive of your position, correct?
That is correct.
And when they signed those documents, I noticed they did not sign it under what they call the penalty of perjury language, which is a statement that says, hey, this is a really important thing that I'm saying. There's important issues to be decided, and to kind of impress upon me as the writer, I'm declaring this under the penalty of perjury. So in essence, they're saying they've got some skin in the game, and they're not going to fabricate, and they're taking this very seriously. So that that language is absent. So I'm concerned about proceeding today without those documents being signed with that kind of that reminder, the gravity type language being included. So do you have any comments on that, Ms. Gizy, or concerns?
No, they just volunteered to write me something because of all the marks that they put in their plan that they give to me about how I don't feed, clothe, or house my kids.
Okay.
So that was just them coming in to say that they've seen it happen.
Mr. Gizy, do you have any comments related to those declarations not being signed under penalty of perjury?
I mean, I got no issues other than two of the people that wrote a statement. It's more of their feelings towards me testifying in a custody case that the one lost her kids and then the other person who wrote a letter is her mother. So theirs is based off of more of a vendetta than truth.
Okay. All right.
So I would like that, what you were saying, the proper way of them filling it out.
Yeah, I think as a general, we have these particular rules for a reason, and you know, there's important matters that are being decided here today, and those affidavits being signed under penalty of perjury impresses upon people the gravity of that, what they're saying is accurate, because what the parties, or what Mr. Gizy is asking the court here today, is to make factual determinations based on evidence that's presented by witnesses, and those witnesses are those that signed declarations under the penalty of perjury. So I think it's important enough that I would like to see those documents revised, and if those same declarants are comfortable signing it under the penalty of perjury, Ms. Gizy, you could resubmit those with those particular signatures, and then we could move forward, and then the court could feel more assured that the factual findings that I would make are supported by adequate evidence.
Okay.
So that's a long way for me to say, I think that's important enough that we should continue this matter to allow for those to be refiled with that language. So we could look at a 2-week period to set over to the 24th of January, and I'll just ask the parties to look at your schedule to see how that looks.
That works for me.
Okay. Ms. Gizy?
Should we remind my boss?
I have one more question.
Oh, I apologize, Ms. Gizy. There's some crosstalk. Could you state that again?
I said I should be fine. My boss works with my court issues that's going on right now.
Okay. All right. All right. Thank you. And then somebody else was speaking. Was that Mr. Gizy? Were you making some comments earlier?
No, I just said I had a question.
Okay, and I think you said that you were saying that you didn't have a question. Is that because it was a little garbled? I couldn't.
No, I have a question.
Okay. All right. So, what's your question?
I wasn't going to get people to write because of the reason we're going about all this. None of the people who have testified in these letters know of the actual reasons of why we're going to court. And so am I able to get people to write letters as well in the timely manner of setting it out?
Yes. Yeah. Anytime that a party makes a motion, they can support it with their declarations or affidavits. The responding party can supply affidavits or declarations from individuals, and then the initial petitioning party has an opportunity to submit what they call reply affidavits. There's a limitation, so I'd encourage you to look at local rule 88. That'll give you the guidelines on page limits and the number that are involved. So local rule 88. If you go to the Cowlitz County Superior Court website, you just click under rules and look under local rules, and it'll pull up the exact verbiage. And I'll give you the guidance that you need. So with that stated, I'll continue this matter to the 24th of January at 9 o'clock in the morning. Make sure that you, both of you, can get those documents into the court, and we'll address that issue on the 24th. Any final items, Mr. Gizy?
Yeah, so are we pushing both motions over then?
I'm showing that you have a motion for adequate cause and a motion to modify the parenting plan. So
yes,
that's what you're talking about.
I have the cause for the temporary parenting plan, and then the motion to change the parenting plan.
Yes, yeah, both matters will be moved to that date.
I just wanted to verify.
Sure. Ms. Gizy, any final questions from you for today?
Do we just continue to follow our current parenting plan?
There's been no change to the parenting plan at this point, so whatever is in place would control.
Okay.
Alrighty. All right. So with that said, we will see everybody on the 24th of January, 9 a.m.
Thank you.
Right. Not hearing a response from Ms. Campa, and then Ruben Campa. Are you here today?
I am, Your Honor.
Okay, welcome to you, Mr. Campa. So going back to Ms. Desiree Campa, Ms. Campa, if you're on the line today, I can't hear you if you are speaking, so I'd encourage you to unmute yourself. You can do that by pressing the mute icon on your device or computer, or you can simply press *6 if you're calling in with a phone number. So again, Desiree Campa, are you here? All right, I'm not hearing a response. Back procedurally where we've been is that we were here last week on the 3rd of January. And I believe Mr. Campa was here on that date. And I'm just going to pull up and verify whether Ms. Campa was. She was not. We set it over to today. And let me just look back here as far as service. Service of the documents was upon Ms. Campa was effectuated on the 17th of December by Ms. Clements. And then it was noted for a hearing last week on the 3rd. There was some indication that
I believe it wasn't within 21 days, Your Honor. So we moved it to this week.
yes, yeah, that's right. Okay, so looks like service was proper for the documents, and so she received those documents, and there was a docket notice that was going to be noted for hearing last week. It wasn't. She was not present on that date, and she's not present today. So I have a proposed order that's been submitted by Mr. Campa. That's an order on adequate cause to change or modify a parenting plan, and you're asking, I think, Mr. Campa, if I'm correct, and you can correct me if I'm incorrect, is that there was a June 2nd, 2023 parenting plan order that has 4 phases of visitation. And you're asking that you move from the phase 1 to phase 2, which would mean 6 hours a week unsupervised, and do that for roughly 6 weeks or so. And that you're also asking for an additional 2 hours makeup time for the contempt, which was ruled upon back in December. And so that, so you're asking to move to phase 2, which would be 6 hours a week unsupervised, and that you're asking for makeup time to occur over that phase 2 time period, which would be roughly 2 to 3 hours added per week. Is that what you're asking for?
Correct. Also, with that being said, I haven't seen my son in over 3 months, and if she is not able to abide by the court, I'd like to ask if there's something that I could do in order to see about getting custody of my son, since she's not able to follow the court's orders.
So anytime there's a court order and one party feels that the other party is not following it or not abiding by the court's order, a party can bring a motion in front of the court. It could be a motion for contempt, saying, hey, this person has willfully not followed the court order. And then you can ask the court to make that finding and then make additional findings for possible change of custody or change in visitation. So that's one option, is a motion for contempt. The other option is a motion for what you've kind of done here is that you've made a motion for adequate cause to change the parenting plan. You could make an additional motion to related to a change of custody. So those are your 2 options.
Would I have to do that? Could I do that today, or do I have to serve her with those documents? Because
you'd have to serve her with documents to change custody.
Okay, because as it is now, it's she doesn't accept mail from anybody when I tried to have her served, so it was difficult enough getting this court situated for today.
Right.
So I'm just because she was held in contempt, and still, even after being held in contempt, I haven't seen my son. So I'm just wondering if I could just move to the next one and try to get that situated because I haven't seen him, like I said, in over 3 months.
So I'm looking at the order of contempt from December 6th. It made a finding that she is withholding professionally supervised visits and impeding my forward motion in creating a relationship with my son. She's unwilling to bring my child to professionally supervised visits. She's falsely accused me of something and using that as an excuse to withhold the child. There's, so the court made a finding of contempt and then had ordered makeup visitation to be scheduled with a professional supervisor according to their availability. And that was the court's ruling. So those are your options. You could bring, basically you would be bringing a motion, and you can do that one of two ways. You could bring a motion for contempt because the court ordered that makeup visitation would be scheduled. If you feel that she hasn't followed that, you could file a motion for contempt for not following that. And then you could also make a motion related to change of custody.
And would I be able to do both of them together, or just either one or the other?
That's up to you how you want to address it. You could file one, or you could file both, and you'd also have to serve her.
And as long as she's still at her current address, I just have it served to that address.
So I was noticing that you most recently served, or one of your helpers served her at the house.
Yes.
So there's different ways to effectuate service. Personal direct service is obviously the best. And so if that works, then do that. There's other ways to effectuate service, but you'd have to research that and do that.
Okay.
So for today, so I'm making a finding of adequate cause to modify the parenting plan to allow for going to phase 2 and then makeup time being granted. So I'm just going to write that into this order so it's a little more clear. And the record will reflect also that Ms. Campa did not file anything in opposition to Mr. Campa's request. Right, Mr. Campa, in your proposed order on adequate cause to change the parenting plan, I added the following in paragraph 5. It reads, Mr. Campa is permitted and does now move to phase 2 of the June 2nd, 2023 parenting plan order, which allows for 6 hours per week of unsupervised visitation. Additionally, Mr. Campa is granted makeup visitation for time he was denied with the child. Mr. Campa is granted 3 additional hours per week of makeup time while in phase 2. And I'm just going to add a parenthesis, unsupervised. So that order, I'll go ahead and sign that order now. And then, Mr. Campa, you've indicated that you have concerns related to not seeing your child. I gave you 2 options that you can address that would require service on her, and then we could take up that matter once you've docketed that and served her.
So, in regards of getting something in line for me being able to see my son, I have to have the person, Sabrina, that I have documented that can do the exchange. Do I have her contact Desiree to set those up, or I'm just trying to see what my next steps are as far as me being able to see my son.
Are there any restraints on either party? Any restraining orders? No contact orders?
Yes, she has a restraining order on me.
Okay. So you need to contact her to make those arrangements, but you have an order that says you cannot contact her, correct?
Yes.
Do you have the cause number of that order in which the restraint comes from?
I have it probably in my stack of documents. I'd have to find it.
Okay, let me see if I can find it here brief. I'm just signing into my system. Does the no contact order come from a criminal case or a civil case?
I think it may be a civil case.
So it looks like there was a no contact order entered on June 20th of 2023 in a criminal matter that was a motion to modify. So it says the order protecting Desiree Campa is modified to allow third-party contact to effectuate visits as said in phase 1 of the parenting plan in the case that we're dealing with today. Information between third parties must be made through our family wizard or through professional supervisor only. All other restraints of contact remain as set forth in the original protection order. So there's a specific carve out there, Mr. Campa, where you can use a third party to contact Ms. Campa to set up visitation. And apparently that needs to be done through the app, Our Family Wizard. Do you have that app?
I do not, but I can download it today.
Okay. So it's either through the Our Family Wizard app or through a professional supervisor that the contact is allowed to arrange for that visitation. And again, this is a June 20th, 2023 order modifying a protection order.
So I would have to download the Family Wizard app in hopes that she has it and be able to contact her with somebody else, or I could message her on there myself. I just want to make sure because I don't want to break the law.
Yeah, I'll read the language to you. It says this. It says the order protecting Desiree Campa is modified to allow third-party contact to effectuate visits. Information between third parties must be made through Our Family Wizard or through professional supervisor only. So those are the two means of contacting her through a third party, is using Our Family Wizard or a professional supervisor.
And then when I sign up for the Our Family Wizard, is it gonna like appear that she's on there so that somebody else can message her for me?
I don't know.
I
don't know. If the parenting plan, in this case, in the family law case, requires that, then I'm assuming there's a parenting plan from June 2nd, and I'll see if that has any language related to the Our Family Wizard app.
Because I'm not really sure how that works, and if she's not willing to come to court today, I don't know how I'd be able to communicate that with her. So that's the next, that we're moving to the next phase and everything.
Yeah, so I'm looking at the June 2nd parenting plan. Under paragraph 14, it says parents shall utilize Our Family Wizard to exchange information about the child. Ruben Campa shall utilize a third party to avoid violating the protection order until the order expires in 2031. So that the parenting plan requires both parties to use Our Family Wizard. So that's what the order requires, and that's how you should proceed. Either that. So those are your options: the Our Family Wizard or a professional supervisor.
Okay, so if I message her on Family Wizard, I won't get in trouble, or.
The parenting plan says you have to use Our Family Wizard. The motion to modify the parenting plan in the criminal case says you have to have a third party send that message. And I don't know how that works because you sign up for the app under your name. So proceed cautiously, but that's kind of where you're at.
Okay. All right.
All right. All right, so Mr. Campa, I've signed off on that order. I'll allow you to make what other future motions that you feel are appropriate to bring those forward to the court. And, you know, any information related to Our Family Wizard, your efforts to contact her through that third party and the third party app, you can bring that forward to the court and detail what's happening.
Okay.
Okay. I know that's less than satisfying. I can't give you legal advice. I can give you options. And so hopefully with those options, you can make an informed decision.
Okay, thank you.
All right, that'll conclude the case for today. Thank you. Joshua
Thank you, Your Honor.
Chavez, are you here today?
Yes, I am, Your Honor.
Okay, welcome, Mr. Chavez. And Kyrene Chavez, are you here today? All right, and is that your correct pronunciation of Kyrene?
Huh?
Do you pronounce your first name Kyrene?
Yes.
Okay, great. Feel free to take a seat wherever you'd like and just kind of position yourself close to a microphone. Ms. Day is the guardian ad litem in this matter, and I'm not sure if she's on the court call today. Doesn't look like she is, and she may have exited the case. I'm not exactly sure. So we're here on Mr. Chavez's motion for contempt related to the parenting plan. And I'll just double check with Mr. Chavez. Did you serve the documents related to your motion to Ms. on Ms. Kyrene Chavez?
I didn't serve her. I had my stepdad serve her.
Okay. Did your stepdad or you fill out what they call a declaration or an affidavit of service?
I believe not, Your Honor.
Okay. So the way we kind of work in courts is everything has to be documented. So if somebody served documents upon Ms. Chavez, then they would need to fill out a document called an affidavit or declaration of service, file that with the court, and so the court knows that that was effectuated. So at this point, there's been no proper service, so we're not in a position to go forward today. So my proposal is, since there's not been proper service, we strike the hearing, and if Mr. Chavez wants to continue the matter or to pursue the matter, that affidavit would have to be filed related to the service, and then it could be noted up for a new date. So that's kind of where I'm at, Mr. Chavez. Do you have any questions?
No, that's why I wanted to do a dismissal on it, because I forgot to print out the return of service letter, what you were just saying.
Okay. All right.
So that's why I was trying to catch you early in the court, so we wouldn't have to sit and wait.
Right. Understood. Any comments?
This is not the first time he's done this, because the person that serves papers to him and back and forth to make no mess. And he has done this before. I did get served because I have the papers in front of me, and all of it is not true. And I keep missing work because of these stupid allegations. I can't. I have 2 kids. I don't get child support for him. I'm missing work.
Your Honor, can I say something? She's been in contempt of court once already, and nothing happened to her. And she was found guilty with that. The last time I took her contempt of court.
No, I see that. In May, there was a May 2023 contempt order. I reviewed that. But as far as today, it's not properly before the court without the service issue. So I apologize that that's not present. Obviously, that imposes a burden on Ms. Chavez and her ability to care for her children and keep a roof over her head.
She's just playing the courts. She's always been. This has been her mess since the beginning.
So we'll look at continuing this matter. Mr. Chavez, do you plan to file that affidavit of service?
No, because I don't have the evidence to prove that, she's breaking the parenting plan again. So that's why, no reason why I wanted to dismiss it.
Okay, so you want to withdraw your motion?
Yes, Your Honor.
Okay, Ms. Chavez, do you have any objection to that?
Nope.
All right, the motion to show cause related to the contempt is hereby dismissed. It's dead in the water at this point. So parties are free to go.
Thank you.
Thank you, Your Honor.
Thanks. All right, thank you, Ms. Teeley. And then Ryan Dalton, are you on the line today?
Yes, sir.
Okay, all right, welcome to both of you. We're here on a motion brought by Mr. Dalton for contempt. So let me just double check. Ms. Dalton, did you receive the documents that were filed by Mr. Dalton, or pardon, Ms. Teeley, did you receive the documents filed by Mr. Dalton related to the contempt motion?
Yes.
Okay. And let me double check. Did you, Ms. Teeley, file anything in response?
No.
Okay. And let me check with both parties. Mr. Dalton, are you looking to proceed with the motion for contempt today?
Yes, sir.
And Ms. Teeley, are you wanting to move forward today with the contempt motion?
I I would like to say my part of it.
Okay, that's
yeah.
fine. That's fine. Yeah, you'll generally the way we do that is the moving party, the party who's asking for the contempt will go first, and then you would have an opportunity to hear what he has to say, and then you would speak your piece and say what you believe to be true and accurate. Then we'll turn the time back to Mr. Dalton, because this would be the first time for him to hear what you're saying, and he would need an opportunity to respond to that. Since you know what he's going to say, so you have an opportunity to respond to what he has to say. You also have the opportunity to share different viewpoints or new information, and then he would have the additional opportunity to respond. So that's the order. Mr. Dalton would go first with his comments, then you'd go second, and then Mr. Dalton would go third.
Okay.
All right, so with that kind of under our belts, I'll turn the time to Mr. Dalton. Mr. Dalton?
Yes, Your Honor. So kind of what's happened is I received back in June, I'm sorry, a denial for immediate order on motion to move with children. It went through and was denied. And then in October, that Kate filed. And then in October, I received more paperwork in regards to a similar motion that was not filed through the court, but it was all the documentation leading up to wanting the motion to move. So I went multiple times to the courthouse to try and respond to that paperwork. But every time I came in, they were like, nothing has been filed. This is the first we've known of it, et cetera, et cetera. All we have on file is the denial. And I stressed after the third time coming in that I would like to do something to stop her from being able to leave the state until we had due process and everything was done legitimately, as well as talking to our mediator, which is her father, and pleading with him as well to not allow her to leave the state without us having everything done. I know there was a time constraint and I was fully willing to work with that. I told her dad, I said, I could do mediation from any point. Like, we can work with a time crunch. We could do whatever we want and need to do. I just want it on paper and I want a judge to sign it and just do it right. And I started paying child support as soon as April. I had the child support for November in my hand on the day that I was going to pick up my daughter, which was the Friday after Thanksgiving, to have my Thanksgiving opportunity with my daughter. And I found out that morning that she was no longer in the state of Washington. She uprooted my daughter to Colorado, which is a pretty big deal. I tried everything I could. I called the sheriff's department. And the best that I could do was file this contempt order. Like I said, I wasn't trying to say no to her leaving. I just wanted to do it right, because me and her have both been through this before with her ex. And I just wanted to make sure that my daughter knew when I'd see her, and when I wanted everything to be to where we could both be there and I could say goodbye to my daughter and tell her when she was going to see her dad next. And that didn't happen.
Can I ask you a question? So
yes.
So where is your daughter living now?
She's in Colorado with her mom.
How long has she been in Colorado?
Sometime the week prior to Thanksgiving, sir.
So,
and I had no knowledge of any of it.
Were you ever served with a notice of intended move or intended relocation or move of the child?
Yes, sir. Like I said, in October. And when I got that, I went to the courthouse 3 times to respond to that document. And
what case was that filed in? Because I'm looking at this case and I don't see anything filed related to.
Exactly, Your Honor. She didn't file it. That's where there was the hiccup.
Oh. Okay.
One was filed and denied in June.
Right, I see that.
And then she sent me full documentation. I have it all right here. Sorry, I have all the documentation right here. I know it's hard for you to see. but I could bring this in and I can get this to you. That's not a problem. But it was
Hold
never.
Hold it up again and just show me like the title on the right side top. Okay, so that's the document that was given to you but was not filed with the court.
Yes, and I went in 3 individual times after her dad, because our mediator, about trying to not allow this to happen until we went through the due process, which didn't happen.
Okay, and so your contention is that Ms. Teely violated a court order that by moving with the child to a different state without notice to you.
Without notice to me, without a parenting plan, with nothing. I mean, no real prior knowledge of any of it.
Or even without court authorization.
Yes, yes, sir.
Okay. All right, Ms. Teely, I'll hear from you.
Okay. So I would like to start by saying I never wanted to prevent Piper, our daughter, from seeing her dad. What led to me having to relocate was a whole set of circumstances, but I want to say I did consult with 2 attorneys prior to ever trying to relocate. The first relocation that Ryan Dalton is referring to that was made in June was in regards to a different move entirely. So that's, I feel, irrelevant in this case. And then as far as this
Can I ask you a question about that, Ms. Teely?
Mm-hmm.
So the June 12, 2023 order is where you were asking to move, and I don't know where, but you're asking to move to relocate, and that was denied, meaning you cannot move. And then it's in the order it reads there were no valid reasons to allow the children to move before the other party's deadline to object to the move. Further, it says you need to serve notice of the move and note to a docket if the house sale is imminent. So that's the order you're talking about in June, right?
Yes. Can I just go back to the beginning of what led to all this?
Well,
in March,
if you don't mind, I'll allow you to do that, but just one pressing question, and then I'll allow you to go in that direction.
Okay.
So the child is living in Colorado with you now?
Yes.
And did you file a notice of intent to relocate?
No, there was no ordered parenting plan. We only had a temporary parenting plan in place because of a protection order that I had to take out against Ryan Dalton.
The protection order, which is a 2023 case, it says visitation is allowed every other weekend or as ordered under the family law case, which is our family law case we're talking about here now. So there it specifically orders every other weekend visitation.
Okay.
Has that occurred?
It was occurring until I had to leave.
Okay. And so then if the court is ordering every other weekend's visitation between father and daughter, and there's a motion for contempt related to that and also the move, what's your position?
Back in March of 2023, Ryan Dalton assaulted me in front of our daughter. Prior to this, I was a stay-at-home mom and homemaker. When the assault happened, Piper and I had to seek shelter in a domestic violence shelter. We stayed there for a week. Ryan Dalton was asked to leave our home that we owned at the time by sheriffs so that Piper and I could return to the home, at which point we did after a week of staying in the domestic violence shelter. And at which point we had to proceed with selling the house because I couldn't keep the mortgage. I had no income of my own. So the motion for relocation that I'm sorry for being upset. The motion for relocation that I originally filed with the court in June was to allow for a move from our home on Abernathy Creek Road into town into an apartment that I could afford for my daughter and I. So once I made that move into town, I had no choice but to make the move. The house was sold. I couldn't make the payments. And I stayed in that apartment. I had no family in Longview. I have no friends in Longview. I was on TANF to help pay bills and food stamps to put food on the table. I spent 5 months there trying to keep work and our home for Piper and I. I did everything I could to ensure that Ryan Dalton saw his daughter. I want them to have a relationship. This move was not to take her away from him. It was because I couldn't afford my rent anymore. I had no help with Piper. I couldn't hold down a job because I had no childcare. I had no help with Piper. Piper kept getting sick over this time frame. So I consulted with 2 separate attorneys asking them what I need to do to remedy my situation. And they told me to fill out and serve him with the notice of intent to move with children. And I did that to the best of my ability. I consulted with them both, told them all the steps I was taking, and I thought I had taken the right steps. I waited the 30-day objection period to hear from Ryan Dalton that he objected to our move. I didn't hear anything. I tried my hardest to make sure I was following the law and abiding by the law. The attorneys told me that I was free to move because I couldn't provide for my daughter there. I'm living with my parents here in Colorado. My mom came and got me around Thanksgiving because I had tried to stay there. I didn't want to rock the boat or cause trouble by leaving, but I had no choice. I couldn't pay the bills anymore.
Okay. All right. Any additional information, Ms. Teely, you'd like to share?
I sent Ryan Dalton the notice of intent to move in certified mail. I have a return receipt. As you saw, he has the documents. We were in court last week with a motion to modify our protection order. I had made that motion in order to accommodate mediation so that we could come up with a parenting plan. And at this point, I want Piper to see her dad. I just want to stop the fighting. This has turned my life upside down, and I've been doing the best I can to provide for my daughter and I, and this isn't helping anything. I want Piper to see her dad.
Thank you. Let me ask you one question. There's a specific allegation Mr. Dalton makes. He says that there was not a visit on November 24th, which was the weekend, I believe, of Thanksgiving. So my question is, was there a pattern of visits that was occurring under the guidance of the restraining order, that every other weekend that we had talked about before?
Yes. And we also, through my dad communicating with him, we did ask him if he wanted to have additional time with Piper around Thanksgiving. And he had said no, he didn't.
So that weekend of the Friday is the 24th of November. Under that every other weekend, would that have normally been Mr. Dalton's time for visitation?
Yes, it would have. But from my understanding, the way the whole thing went down was that he had the 30-day objection period that he didn't raise an objection to. So I thought I was in the right to go ahead and make that move from what I understood about it.
Okay. Okay. All right. Mr. Dalton, anything in reply?
So, regarding Thanksgiving, my scheduled day was Friday to Sunday. Mind you, I live in Seaside, Oregon, and I for one reason or another, I didn't get to see my daughter till the week prior to Father's Day when I started seeing her. So then after that, it was every other weekend, and I drove to and from, which is a 3-hour round trip drive to visit and see my daughter, pick her up and drop her off. I had no assistance in that at all. But on the Friday after Thanksgiving, when I was supposed to have my daughter, I had my child support checks in hand, literally I drove to Longview just to find out that my daughter was no longer in the state. And in that time, I've not only missed Thanksgiving, I missed her birthday, I missed Christmas, I missed New Year's. I filed everything as I could. And as far as not responding to the 30-day notice, I went in 3 times, and I not only did I go in 3 times and was refused response because there's nothing to respond to in the court's eyes, I pleaded with her father for the course of the 3 weeks that this was going on that she did not go about it the right way. I literally was trying to, I was basically giving her everything she was requesting. I just wanted it done through the courts. I wanted a judge's signature. I wanted the divorce done. I wanted a parenting plan. Like I said, I wanted to be able to go to the airport, give my daughter a hug, tell her I love her, and tell her when she's going to see me next. And that was stripped from me. Like I've said, I missed her birthday, holidays. And at this point, the other thing that perturbs me is that I am more than capable of having my daughter, Your Honor. I've held down a job. She was a stay-at-home mom due to me working full-time. Not only that, I could have been more than capable to take my daughter for the time being. I would never try to take my daughter from her mom. She needs her mom. She needs both of her parents in her life. But I would have been more than happy to take my daughter during this rough time in her life, let her get back on her feet, and then, she could start having parenting visits and et cetera, et cetera. I think due to her past relationship and her ex situation, she tried to not allow that. And with that being said, and I told her parents, I said, not only are you taking in your daughter, but you're also taking in mine. And that was without my consent. I'm more than capable of having my daughter, taking care of my daughter, not asking for child support, not asking for anything, just let her mom get back on her feet and go from there. But I was never given the opportunity. Like I said, as far as the response goes, I literally have text conversations, paragraph conversations with her father, pleading him, hey, she did not go about this the right way. Don't let it happen. I'm willing to work with you, time crunch, et cetera, et cetera. At this point, the protection order is 2 months away from being over. She's 1,700 miles away. So a modification that we went to last week should have just been a complete dismissal, in my opinion, so that we could move forward. I did everything I could, Your Honor, to accommodate this move, but they just went about it the wrong way. And all I'm asking for is now I'm having to go through this battle. I agree with her. I don't want to fight. There's nothing to fight about. Everything's already we've been separated for going on a year. At this point, it could have been a simple mediation, adjust child support, adjust the parenting plan, come up with a strategy, sign, seal, deliver, and have been done with it. But they refused to listen to me because I like I said, I went to the courts 3 times and tried to respond to this, and the courts wouldn't even allow me to respond because there was nothing technically to respond to.
Okay. All right. Thank you.
Could I say something in response?
Briefly.
The only response that we got from Ryan Dalton, we did not get anything until after the 30-day rejection period. He did not acknowledge that he received the notice of intent to move or anything until right around Thanksgiving, which at that point is when he finally said all those things. So it's not like he was pleading for us to not leave and we just left anyways. We didn't even get those until we were actually out of the state.
Okay. All right. Thank you.
That's not true, Your Honor.
I'm ready. I've heard from the parties. So there's a motion for contempt that's filed by Mr. Dalton that alleges that his parenting time was denied. So this case it's not quite as straightforward as an average contempt, in that there's not a temporary parenting plan in place in the family law case. That's the case we're in here today. However, there is the protection order in the criminal matter that specifically references this family law case. That order is effective until sometime in March of this year. And it specifically allowed visitation every other weekend of Mr. Dalton and the minor child. And so the parties acted upon that, and there was apparently a visitation schedule that was set up, and Mr. Dalton was exercising that visitation. And it was kind of on this every other weekend. And the specific allegation in the motion for contempt is that on the weekend of the 24th of November, that visitation was denied. So I look at a couple of different things here. One, I look at the family law case. There's not a specific provision that establishes it. However, there's a restraining order, a criminal matter, that makes specific reference to the family law case and specifically orders for visitation to occur on an alternating week basis. So also is important to note that the notice of intended relocation was never filed with the court. So when parties initiate litigation, they necessarily involve a third party, the court. And when any party wants to do something, generally it's under the supervision or auspices of the court. Here, while Ms. Thiele apparently gave a notice of intended relocation to Mr. Dalton, the court was never apprised of that. And so when Mr. Dalton apparently tried to respond to that, he couldn't because nothing had been filed. And so any action that takes place needs to be under the supervision of the court. That way, everybody knows what's going on. And if there's discrepancies or concerns, they can come to the court and argue their point to the court. The visitation on November 24th did not occur. And so based on that, I will make a finding of contempt that Ms. Thiele violated a court order by denying that visitation. And I recognize there's a lot of extenuating circumstances involving divorce, relocation, job, finances, ability to care for a child, a safe place to be, having an apartment or a place to feel safe. I recognize that, and that's compelling information. However, the court had ordered an every other weekend visitation, and that did not occur. So I'll grant the motion for contempt, finding that Ms. Thiele willfully violated that provision in the restraining order that makes reference to the parenting plan. I think where the parties are at now, so as far as a purge condition, in order to purge that finding of contempt, Ms. Thiele can purge that by allowing for visitation to occur on that alternating weekend basis. I think here in the future, there needs to be a parenting plan established. So either party is free to bring a motion to establish a temporary parenting plan. And I think there needs to be some guidance set up there, and we need to hear from both parties. So either party can initiate that motion for a temporary parenting plan, so there can be a little more order and potential guidance for the parties as far as the custody and visitation of the minor child. So I will prepare an order on contempt, and I'll file that with the court later today. And then the parties, if you need a copy of that, you can contact the clerk's office and check with them, and they can get you a copy. So that's kind of where we're at today. So that's my ruling. Does anybody have any questions?
Yes.
Go ahead, Ms. Dalton.
As I had already stated, I motioned for a modification of the protection order in order to do mediation so we could come up with a parenting plan. Is that not sufficient for asking the court to come up with a parenting plan for us?
So mediation is separate and apart from the court. It's encouraged by the court to have the parties mediate to see if the parties can come to an agreement. If the parties can come to an agreement, then the general course is that the parties would prepare an agreed order, submit it to the court and say, we both agree, this is what we want, and the court would sign off on it if it seems appropriate. However, if the mediation is ongoing or is unresolved, then any party's free to bring a motion to for a temporary parenting plan, notwithstanding mediation is permitted by that other order that you were mentioning. So it's kind of a dual track. We as a general rule, we want to resolve cases, and if cases can be resolved through mediation, fantastic. If they can't be resolved, then come to court, fantastic. But the idea is to resolve cases. So the mediation, that's permitted. The parties are encouraged to do that. And if after engaging in that mediation that there's not an agreement, then the parties would come to court and ask the court to make a decision.
Okay, it's just since I'm in contempt of court and I can't, there's no way for me to get Piper to see him. I don't understand what I'm supposed to do. It just doesn't seem fair. You know, I was doing the best I could as a single mom. This is like a result of his actions.
No, and I recognize there's a lot of different factors that go into this, and like I said, from a emotional standpoint, very challenging circumstances. So the contempt is I've made that finding. Sometimes people can purge their contempt, other times they cannot purge their contempt, and then that would move to the next step of which would be mediation. If the parties agree, great. If they can't, then there'd be a motion for temporary orders.
So I just I don't even understand what it means to be in contempt of court if like I have repercussions or something happens to me about it. And like I said, I'm already trying to facilitate a relationship between Piper and her dad by requesting I can't contact him and he can't contact me. So the only way we could do that is through mediation, and the protection order doesn't allow that. So that's why I made that motion. I'm not in contempt of court. I'm trying to work with him.
So I'll file the contempt order, and then I'll allow the parties to proceed as they deem fit. That'll conclude today's hearing. Thank you.
Your Honor, can I say one thing?
Yes, go ahead.
As far as everything goes, I mean, mediation is the end goal. Like I said, that's what I wanted from the get-go before everything happened. With that being said, as far as trying to see my child, what's going to be the best course of action for that? Like, because I know that it's going to be about anywhere from $1,000 to $1,500 to fly her out unsupervised. Me and her have both been through this, Your Honor, and it's one of those things where I deserve to see my kid, and that was taken away from me, and now I'm just trying to figure out how I can do that best. And I agree. I am going to file. Mediation would be ideal, and that's really all I was going for from the start of this with the whole contempt thing, is just let's do it the right way.
Okay. All right. So I'll file that order of contempt, and then the parties, if the motion to modify the restraining order allows for mediation, then the parties can seek mediation, and if that doesn't work, then the parties can seek a motion for a temporary parenting plan.
Is there any way that we could just dismiss that protection order so we can get this started?
So the no contact order is in effect until sometime in March of 2024. If any party wants to modify or terminate that, they're free to file a motion to seeking that dismissal or modification, just as Ms. Thiele has sought modification of that restraining order. Any party can file a motion to drop or modify.
Yes, sir. I understand. And I know we have a court date set for the 22nd to come back on that. Means how we're just a couple months out. I would just like to advise Kate to just drop it and let's start mediating as soon as possible.
So we'll need to wait for that hearing date to come, and we can address it at that time. And then if it's granted, then mediation can ensue thereafter.
Yes, sir. Thank you, Your Honor.
All right. That'll conclude today's hearing. Thanks to each party. Okay.
Thank you.
To you. And I see Mr. Michael Wood, you're present also? Yes. All right. Very good. All right. So this is a motion brought by Ms. Wood related to a quick claim deed on the house on 33rd Avenue that was encompassed within the July 14th, 2023 dissolution order. It looks like there was proper service effectuated upon Mr. Wood. That happened on January 2nd, and we're here on that matter. So, Ms. Wood, do you want to start off and you can tell me your position, then we'll hear from Mr. Wood to hear what his position is.
With my divorce, I was granted the house. I've tried to set up times on the weekends to meet up with him to sign the quitclaim deed. He said, yeah, sure, we can do that. Then back out at the last minute. I made another appointment. He was notified of it. He said he could be there, and then he changed last minute, said, oh, I've got plans. Well, he lives literally right down the road from me, and he was home the whole time. So I want what was ordered in my court case for my divorce to be done so I can move forward with my house and actually be able to do things.
Don't interrupt. Sorry. We're not going to interrupt. As you've probably noticed when we do our proceedings here, I apologize, Ms. Wood, is that I hear from one party, they speak their piece, even though there's disagreement, then the other party is able to express their disagreement. We'll proceed under that rule. Go ahead, Ms. Wood.
And I've tried to be nice about it. I was behind on my payments. I worked with my mortgage company. They needed papers signed by him because he was still legally on the house. I did get his name off, but legally the quitclaim deed has to be signed so it can be filed with Cowlitz County, the records or whatever. I've been nice about it. I've tried numerous times. He said, yeah, we could do this. Never happens. And it's just putting a damper on things. It's like, you don't live here. You don't pay the bills here. It was granted to me in the divorce. Just sign it. Be done and over with it. Move on.
All right. Thank you. Mr. Wood.
The house we purchased, okay, I made all the payments for 5 years. I remodeled 2 bathrooms, a bedroom, a front room, a garage, put a lot of blood, sweat, and tears into the place, a lot of sweat equity. When Miss Wood asked me if I would go and sign this paperwork, I told her I would do that if she would buy me out of it. Buy me out of it. $30,000 worth of work that I put into it, buy me out of it. Or sign some kind of a contract with me and we'll have it notarized saying that if you choose to sell the house down the road, anything over what the house is worth or whatever you make, we split that. And she said no. So I didn't go and sign the paperwork. And the next time that she asked me if I would go out over there, I was actually thinking about it, but I haven't seen my son in 4 months. And I asked about that. And she just won't. She keeps saying that he could come down there anytime he wants to. And when I talked to him, he finally responded through a text and he said, no, by law, Mom said, I am not allowed to go down there and see you. Otherwise you will get in trouble, Dad. And he said also, quote, she showed me the paperwork. And he says, I read the paperwork also that said that I am not allowed to see you anymore.
Let me ask you just a couple of clarifying questions. It looks like there was a parenting plan that was established or signed on July 14th of last year that provides for primary custody to Ms. Wood and that you have visitation, let's see, that you have alternate weekends, Saturday 10 a.m. to 2 p.m. and then Sunday 10 a.m. to 2 p.m.
Right.
So have you filed? You indicated that you haven't seen your son in 4 months. Did you file a motion for contempt or a motion to see your child?
No.
Okay. And then
I do have some, I have a modification for the parenting and I'm in the middle of filling that out.
Okay.
The parenting plan and modification for the child support because it's $3,900 a month and I only bring in about $2,400 a month. And so I'm in arrears. I'm backed up 22,700 or 22,500 already, and it's only been 5.5 or 6 months that we've been separated or divorced.
Okay.
So I'm trying to get that under wraps, but I'm so broke. I mean, a little over half of my paychecks are going to her. They're taking 50%, and then because I'm in arrears, they're taking a little bit more. And so, like, if my check is 1,200, she gets 700, and I get 5.5, 550, something like that. So I'm just barely scraping by and trying to make my truck payment and my Home Depot card payment, my loan payment for the $5,000 that I took out to get to Alaska to make good money, because I thought things were getting better between the two of us.
Then let me ask you, so on July 14th, the decree, I think it's the decree, indicates that the home was granted via the decree to Ms. Wood.
Right.
And to get to that point, was that based on, that was an order of default, correct? There was an order of
Yes.
default. Okay. So where that kind of puts us at, you're making a claim of basically sweat equity, the contribution, that you're asking for additional monies because there's been value given to the home based on your sweat equity. So that's the reason I ask how that July order giving the house to Ms. Wood came about. Because if we were at a trial, say we had a trial, right? And then the court heard from everybody, they heard about this sweat equity, the $30,000. It sounds like there's extensive remodeling that occurred. The court could take that into consideration and fashion a remedy that would be equitable and hopefully fair to both parties. Here, where there's a motion for default and an order for default is granted, then none of those considerations come into play. In other words, because the default, you didn't respond to the initial pleadings, and then that default was entered and without hearing your voice, that's where we're at. And so your voice, by not responding, was silenced, right? And so once it's been silenced, then we're kind of proceed from them there forward. And so the there forward was the house plus all the remodeling and efforts was deemed to go to Ms. Wood. And so that's kind of where we're at now. And so it's difficult to undo, how we got here and where we're at now, because there's this desire for finality in these rulings. And so, I hear where you're coming from, sweat equity, remodeling extensively a home. It doesn't seem fair that she gets the benefit of all that. Nonetheless, there's the
kids, the dog, everything, and I get absolutely nothing. And then she gets half of everything I make. And I'm about ready to be homeless. So
yeah, it's a tough position I think for everybody here. So the order is what the order is. This happened in July, and sometimes if there's something that needs to be rectified or some wrong has been committed by the court in its ruling, then a party can ask for either a reconsideration, hey, look at this fresh with new eyes, or you can appeal it to the appellate court and say, hey, this is really wrong. I need some relief. Please fix this. Neither of those two things have happened. And so we're here on a motion where Ms. Wood is asking that the home be properly be given to her the title by signing of a quitclaim deed. So that's kind of where we're at.
Okay, let's just sign it. Let's get it over with. I'm one out of my life.
Okay. So what I was thinking of doing is I was going to appoint a special master, which is basically one of our court commissioners that has authority to execute a quitclaim deed on your behalf, because it sounds like there's been efforts in the past to make that happen. It didn't occur. And it sounds like you were at one time maybe thinking about doing that. But I'm not going to leave that to chance. So I'm going to appoint that special master, and that special master will have authority to sign the quitclaim deed. So I'll need to prepare that order, the special master order that gives that authority to that individual. That's under Revised Code of Washington 6.28. And then that order would be signed, at which time Ms. Wood could present a quitclaim deed to the special master for signature, and then the quitclaim deed would be resolved.
Okay.
So that's kind of where we're at.
May I ask Ms. Wood something?
Assuming that there's not restraining order, no contact order?
There is.
Yeah, so that would be violative of any order if there's
Okay, may I ask you when
So-
my son?
Yeah, so related to parenting plans and the like, if there's concerns that the parenting plan is not being abided by both parties, then a party can file a motion for contempt. So if you feel that you've been aggrieved and you haven't been able to see your son, then you can file a motion for contempt and say, hey, I've been denied visits and I need to see my boy. And then you could file a copy on Ms. Wood, and then she could respond. We would have a hearing to discuss it.
Can I ask a question real quick?
Sure.
So I have a copy of the quitclaim deed that an attorney did up for me. Do I need to bring that to the courthouse or what? So just bring it up there and have them file it with the case?
Yeah, not necessarily file it with the case, but you'd present it to the clerk for filing and say, hey, this needs to be reviewed and signed by the special master that the court has appointed. So it'll basically be one of our court commissioners that will review it and sign it. But you just need to specify that it's to be presented to the special master in the case. And that'll be laid out in the special master order that I prepare.
Okay, so when do I need to bring that up there to have that done?
The special master order, depending on how much time I have today, I haven't drafted one of those in a bit, so it may take a little longer. Potentially it'd be filed today. Hits the system in about 2 days. Today's Wednesday, Friday. So, rough guess estimate would be Friday or Monday.
Okay, so just bring up that form and then the other form that was given to me by the attorney.
Yeah, whatever you'd like to submit. The quitclaim deed, that's the main document. And so.
Okay.
Mr. Wood, do you have any final questions?
I just want to know when I can see my son and why it was okay for him to come down the first 2 months of the divorce. And he was coming down, every couple of days and hanging out. Even if it was just 15 minutes, I was able to get a hug from him and see him and see that he's grown every day. And now he's afraid to come down. He's afraid that one of us is going to get in trouble. And I don't understand that because it's not, the restraining order doesn't say that I can't see him. As far as I know, it just says I can't be around her or his school. I can't go to school and pick him up.
Okay, so it sounds like there's some issues related to the parenting plan that'll need to be brought up via a separate motion. So I encourage you to do that if that's something you want to do. All right, so with that, that'll conclude the matter for today. And I think I'll sign off because I think that's the last matter that was on for today's docket. Just double checking with the parties that are on the Zoom call. Any party needing to have a case addressed that has not yet been addressed. Okay, hearing none, I'll go ahead and sign off.
All right, thank you.